the idea of family and law, they don't really meld well together. But I at least try to think that even though I represent one side, there's still a family here.
Outside of your work bio, outside of your career, who is Miriam Zakarin?
I think first and foremost, I'm a mother of 4 children. I'm married to my law partner, who's just a lovely individual, and we raised 4 kids together. We're doing it. I don't want to date myself because I'm so young, but probably like over 20 years. So it is what it is. But I think being a mother is very important to me. I'm from a nice large family, very family oriented. That's what's important to me. Really spending time with my family is important. And so balancing that, my work life and my family life, is something that I struggle with always. I'm just enjoying time with family. Really, that's who I am outside of work. And that's really what I would want for most of the people that I work with. But I think it's what's important to most people.
It's a really hard thing to do, but we'll leave that for a family balancing podcast.
I don't know if I have the answers though, so you might not be asking the right person.
I'm not going to do that.
I struggle
podcast.
with it.
Yeah. Let me ask you like this. I think one of the most common questions that I get asked is, what happens with the house? And is that one of the, like, the house is like one of the big ones,
you know
or
what?
people moving out? Like,
a lot of times it's the first question I get. Should I move out? Who's moving out? When are we moving out? And if I file for divorce, do I have to move out? Or if I file for divorce, does my spouse have to move out tomorrow? And I have to really.
And if I move out, do I lose the house?
Right. Have I abandoned? If I move, is it abandonment? And those are very common questions. The answer to them is, you don't have to move if you're filing for divorce. You don't lose your house if you move. You do. There is this issue of the person that's in possession of the house has more rights, or maybe more rights to be the person to buy the house out, more access if you want to have the house valued and appraised, and it could slow things down, but it really depends on what your situation is. And it's not one blanket rule. And when people ask me that question, should I move? What should I do? I say, listen, that is a very loaded question, and I need a lot more information to know what you should or shouldn't do. But no, if you move out, that's not abandonment. You know, judges are reasonable people. And if a family's in conflict, and it'll help the family and the children, if one person separates themselves and has parenting time elsewhere, and they're not together, and the children aren't exposed to conflict, and just the couple themselves are not in conflict directly on a daily basis, that's looked at as like, okay, you made the right move. You were being reasonable. You said, I can't live in this situation. We're not good for each other. I want to make this a little bit of a healthier environment for myself, for my spouse, for our children. I'm just going to take myself out of the day-to-day equation together with my spouse, and arrange for a time when I will have time with my children, because that's something that can be concerning. When the other spouse is not going to set an agreement for when the spouse that's thinking of moving sees the kids, that could affect access to the children. And that could make someone have to run to court faster, where they wouldn't want to. They'd want to say, hey, let's mediate. But if you're not seeing your children, the longer the time that passes, it's not good for the spouse, for the parent. It's not good for the children. And so that's a consideration to have, that if you're moving, have a plan. Have a plan that you're both agreeing to when you're seeing the children.
So let's go into detail first. Someone's moving out. Should they get their spouse to sign something that they're not abandoning? Should they notify with a text, notify with the email, or not necessary?
So I definitely think notification, saying, listen, things have gotten very hostile, or I think it's better for us if we're not living under the same roof. I'll be moving. I'd like to, arrange a schedule to see the children. Now, if there are no children, that part doesn't matter. You have much more of an easy exit. That's for all cases when there are no children. It's a much simpler move for both parties. When there are kids, there has to be that conversation.
So they should notify something, like
Absolutely.
Somehow have some sort of communication. By the way, I'm moving out, because like just to keep the peace, or
Right.
but I'm not like, we're going to have to deal with this at some point. Now, on the practical end, now judges are practical, right? So on the practical end, there is a certain part of it, which if someone's living there for 5 years, that would set something, right? Meaning they're there for 5 years. Now you want them to move and you move in is going to be a harder change. Or?
Absolutely. I mean, it's unlikely if the person who's living there for 5 years doesn't want to stay there. If they don't want to stay there, then yeah, the person who didn't live there can move back in. And if the person who's living there for 5 years wants to buy the property out, the judge is letting the person who stayed buy the property out. So the person moving has to know, I just either want somebody to buy me out or the property to be sold. I don't want to stay here anymore. They are really looking forward and saying, I'm done with this place as far as it being a residence for me, but not giving up my ownership interest or equity in the place.
Now, the other extreme of it, someone says, well, I want to go to Florida for a week. Will I lose my house? Or I want to go, the equivalent would be, I want to just go shopping. Like, am I going to lose my house?
Absolutely not. In that case, and I've had some people tell me, like, I was locked out and I didn't know what to do. And you have to call the police in that case, because there are tenancy rights that everyone has to, if they've lived there for the past 30 days, they have tenancy rights to the location. There cannot be a legal eviction. You can't just get locked out of your home. And some people I find have said to me things like, I was scared to call the police. Or I thought if I called it, or I asked a rabbi and a rabbi said, don't call the police. And then they lost their home. That's a consideration where if somebody's in a situation where they're locked out of their home, they do need to speak to an attorney and know what their legal rights are. You could always make the decision, I don't want to call the police, but I think having the knowledge and understanding of what your rights are and then making that decision is a better decision than not knowing what, and then looking back and saying, oh, I wish I knew because I would have made a different decision at that time.
So let's say this, just the flip side of it. If your spouse left the house, don't switch the locks. Don't lock them out of the house. Don't do those stuff.
Do not. It's actually an arrestable offense. And I have had cases where spouses have done that. They've done illegal evictions. They do get arrested by the police. There are criminal charges pressed. And the spouse that was locked out can also get a civil court order of protection, which then it's actually reverse a legal eviction, a actual legal eviction, but not the term of eviction, but the person who had the order of protection against them is now excluded by law from their home. So do not lock your spouse out. Do not change the locks. Those are not things you can just unilaterally do without a serious consequence.
Now, obviously, this is not, there's no legal advice over here. This hopefully
absolutely
would be food for thought, considerations, and for people to hear. I want to, like, the way I like to conduct a mediation when there is a house involved, I like to always separate the house from the money from the house. So it's two separate questions, meaning, like you were saying before, who's going to be staying in the house may have to do with who stayed in the house. But then there's, what do we do with the money from the house? How is the house paid for? So what happens with the money of the house? And let's start first from, are there times where even if it's not going to be equal, obviously New York is equitable, not equal, but where someone might have to leave all their money in the house because even if their spouse can sell it, are those things that happen?
So there's different scenarios where that can happen. So one is where there's children. And there is case law to say that if children have always lived there and it's going to be detrimental to the children for moving them, then the spouse that's the primary residential custodial parent would stay in the home with the children. That doesn't negate the other spouse's ownership interest. And there would be, clauses that would discuss how the spouse that stays in the house pays for things. But there would be an ownership interest that would have to be at a later time, maybe when the youngest turns 18 or the youngest graduates high school, or there's different things that are written into these agreements, or even that are decisions of judges as to when that spouse that's not in the home realizes the equity that they've left in the home. Now, there's so many other...
It would balance out, like...
So there's some questions here because all the interest payments made on the mortgage, those are living expenses. But then when the spouse that's staying there is paying down principal every month, principal is like an investment and a raise in the equity. And it's not a passive raise or a market force. It's an actual, dollar for dollar increase
Lowering
in equity.
the
Yes.
liability.
So some people would say that, well, for the benefit of having stayed there, if there's an agreement, I'm just going to get half of whatever the actual equity is, even though principal was accrued by virtue of the primary residential custodial parent paying monthly, principal payments in addition to everything else paid. And some people would say taxes. Some people would say insurance should be paid. So they would say that the parent that's not living in the home should be paying half of those things. I've had those arguments, and I've had the arguments, if we're letting you stay there, just give back half. That's a fair, continuation. And also,
give back half, you mean the person staying there is paying those payments?
And then when you calculate equity, it's a straight calculation. You don't give credits for the amount of principal paid down by the person that stayed in the home.
And the person that's not staying there had to make payments?
There are cases where the person that's not staying there would make payments, but they would do it in lieu of or in calculation of what their child support would be, what their, if they had a spousal support obligation. And so it would cover certain things, and then they wouldn't have to, give a credit to the primary residential custodial parent when the house does sell. So there's different calculations that have to be taken into account, and there's so many different variations on that. And depending on what the negotiation is and what other factors come in, it can be like, pulled in and out, like just different building blocks.
So let me back up a second. So basically, when someone's staying in the house, they will have to pay for that house some way or another. They're going to have to pay. It's not like, right. It's not like the person that's not staying there has to pay the mortgage, has to pay. No, there's going to be some calculation. And if they are paying for that, it's coming off from somewhere else.
Absolutely.
But there will be some sort of calculation.
Right. It has to be equitable. There's no windfall to one party, and there shouldn't be.
Let me tell you a joke.
Tell me.
The joke is that who's the richest person? The other side of the divorce. Everyone always like, no, they have this. But
right.
Really, meaning especially in New York, where it's so much of a calculation, it's not a zero-sum game per se. Right. Sometimes you could find where there's extra money. You could be creative in that way, but it's not, don't shoot for that.
Right. No, it's not reasonable to shoot for that at all.
Now let's go back to, because the house, there's always a down payment, where the down payment comes. We have, in other assets, you might have commingled assets where you're mixing marital and non-marital. So non-marital, simply put, would be something that came before the marriage or a gift specifically to one of the spouses, right?
Right.
Now, how people pay for down payments, and we would split this also to people that have full houses bought for them. What happens with the house, and how is that calculated? I guess we could start with a down payment. The father of, let's just say, the wife gave $100,000 for the down payment, specifically for his daughter, let's just say. How is that accredited back to her?
So, I mean, there's different variations, because if she can show that this money was specifically gifted in my name to me, and it's a separate property credit, a gift, then very technically that should be a full dollar for dollar credit going back to her from the equity of the home, because that specific gift was to her. Now, there's questions about it, because, what if they're married 30 years and they had the house in joint name for 30 years? And yes, there was a $100,000 deposit, but after that, the husband worked and they fixed the kitchen, and they, there's capital improvements that have been made to the property. And so at what point does that 100,000 still stay a fixed 100,000? So it's not a fixed answer to that question, because there are so many other factors that come after that go into it. Now, as an attorney, if I were representing her, I'd be like, I want all that $100,000 back dollar for dollar. And I would find the case law and I would try to keep making my point about it. And the attorney, if I was representing him, I would say, well, he paid for this, he paid for that. He did this, he did that. We're not, we don't think there's a reason she should get a full or any. And if we settled, we'd settle somewhere in the middle.
But let me, because you took it one way, but I've heard it the other way also, where if someone put down $100,000 as a down payment for, let's just say, a $500,000 house, would they own 20% of the house, or it's dollar for dollar for the $100,000?
So I've heard people try and say that they own a percentage of the house, but it's not true because it's how it's held in title and deed. And if you own as husband and wife the house, you can't say I have a credit of 20%.
But if it was only in one of their names, let's say they put down one of them, it's simpler when one put down the whole down payment. But so let's stay with that. One put down the whole down payment. They paid the mortgage for 30 years. They paid the mortgage from joint money.
But in whose name is the house? Just the person who put the money down?
Let's say.
So that's a little bit harder. That really, if all the house is just in the person who put the down payment down. And yes, the parties paid monthly mortgage payments each month from joint assets. So the person who has the house in their name would say, well, there's been some marital contribution, but this is my separate asset. It's on you. The burden's on the other side to prove their marital contribution. That's how I would see it. And I've had a case like that because essentially the property was purchased in my name alone with a gift directly to me alone. It's my property. The mortgage is directly only in my name and it's been paid every month. Yes, it's been paid by contributions for marriage, but my contribution also. So if my spouse paid half the monthly mortgage payment with me every month and all the rest of the household, so what's to say that his half or her half was the principal payment? Those are living expenses. Why should you get a credit back for just living in my house? So you're
saying there's an argument to be made, but
yes,
that's where you're saying, what I'm understanding is that the difference between owning it in two names, if you have two names on it, then it's essentially owned by both of you. The $100,000 that was put down for the down payment is $100,000 as a loan of some sort. It's premarital, which needs to be paid back dollar for dollar.
Well, not needs. Somebody would have a reasonable ask in asking for it to be paid back.
Right.
It wouldn't be just out of left field. They have a real question of, I put this separate property in, I want a credit for the separate property. And then the remainder would be subject to equitable distribution.
Okay. And I guess let's go to the other extreme where someone bought the whole house in one of their names. And that's where the claim would have to be made on the person that did not buy it. How did you gain any equity, any joint ownership into this house? So did you redo the whole kitchen? Did 50 years go by where you were paying for it? That would be where the onus would be on them.
Yes. And I think I even had a case where it was a very long-term marriage. The house was purchased before the marriage by one party. It remained in that party's name. But at one point, there needed to be like a refinance. And the party that owned the property from before the marriage could not get the refinance on their name alone. And so they used their spouse's name. And they had a very long-term marriage. By the time they came to me, they had paid off that mortgage. But that was, and I represented the spouse that's name was not on the property. That was my in to say, no, you're not taking this property and saying I have no part of it because you couldn't have gotten the mortgage. And I was working and paying bills. And for the mortgage to have been in my name, it means that I had some real liability. And that is how this property was able to be maintained in a real way, not just my paying the monthly, portion of the monthly expenditures for the home. And then there was also the installation of kitchens and new floors, walls, HVAC, whatever else. And so we actually had to bring all the receipts to court and go through point by point all the capital improvements and show the mortgage documents in order to establish what could be said was her contribution to this asset and what amount should be paid to her as her portion of the equitable share of that.
Very interesting. It makes sense, a lot of this. And, in mediation, I think most of the time people know what's fair and equitable, and it falls into place generally. I've had a few times where the spouse that actually owned the house, they weren't necessarily very wealthy themselves, but they had money from parents or whatnot. And several times where the spouse that's keeping the house gave the other spouse a few $1,000s, not much, but a few $1,000s just to move out, just to get set up, because they had more money and because they were able to help them out, at least get up and leave.
Right.
You see that also?
So I do see that, but that's a cost benefit analysis, because you have to think, like, do I want to go to court with this and fight and fight and fight, even though I'll win? In the end, it's going to cost me $15,000, $20,000 just to make that point and win. What did I win? In the end, if I gave $10,000 to my spouse to move out and I did it nicely and we don't have as much acrimony, it might make sense to do it that way than to fight all this and to get, a result that's on paper is helpful to you, but in every other way in your life is really not that helpful because you paid so much for that result.
Right. I like to look at it a little more glamorous, because I don't like to look at it like, well, they were pushed against the wall and then they paid that money. I do like to look at it, and again, I do feel that for sure in the room in mediation, where it's very understanding of the situation and wanting to help the other person out with something that for them may not be that significant from wherever they have their money from, which may not be marital money.
Right.
So I do see a lot of times where they might help the other person out. Now, just to wrap up the houses first, this is a very big topic about strategic allegations and using strategic allegations to get someone out of the house. Your thoughts?
It's a really big problem. And it hurts the people who need services of the courts because they need protection. But it's kind of rampant right now. So on a few fronts, not just to get the house, I've been seeing it for immigration applications. I've been seeing a lot of false allegations of domestic violence. Where when I say seeing, I'm telling you that I see the case and all the evidence way before it ever gets to court. So clients will come to me and say, how could somebody make these allegations? I have evidence it's totally not true. And they'll have recordings, and they'll have a Ring doorbell video, and they'll have text messages and emails that show dates and times counter to everything alleged, or most of what's alleged. And it's clear that they don't really have a good case. But till it gets to the point where it's adjudicated, can cost somebody so much time, so much money, that they essentially settle for getting out of this. What can I settle to move on? Never really having that vindication of this is false. So it's a rampant issue. And when clients approach me, and it does seem, I know that for me, a client approaches me, they want to tell me what their version of the story is, and I should just accept it because they're the client and whatever they say goes. And that really should be true. But I like to make sure that if I'm bringing someone to court and I'm representing them, I'm not doing them a disservice by allowing them to be not truthful in a way that's going to come back to hurt them even more. Because the only currency that you have in court is credibility. And if that is being chipped away, nobody believes anything that person says. And so I do stress it. I have had clients come to me and say, well, I think, so-and-so, everyone throws around the word abusive. My spouse is abusive. So I say, what does that mean to you? What do you mean by abusive? Well, when I asked him to buy milk, he yelled at me. When I told her, that I don't think it's right to put the kids to bed that late, she told me to go whatever myself. I was like, well, that's not abuse. It's not nice behavior. It's maybe what people can be calling marital contretemps. You're fighting, you're arguing, the reason you're divorcing. But stop using the word abuse where it's not abuse.
Would you say that it's overly glorified in some ways to to allege abuse?
I don't know about overly glorified, but I feel like there's a culture of victimhood that's really just pervasive right now. And everyone wants to identify in some way as a victim. And I know it sounds pretty terrible of me to say, because the reason I say it is because it hurts actual victims of domestic violence. They're the ones who are being looked at skeptically. Nobody wants to believe anyone anymore because everyone just makes allegations of abuse and they throw it out there, and they don't really understand the magnitude of those words, and they're hurting people who are really victims. Fighting and having a disagreement does not mean you're the victim of the person you disagree with. That's a disagreement. I don't think it's being, it's one thing to also misunderstand and misuse a word. And then it's the step farther of, I know I'm not a victim of anything, and I'm going to make something up to achieve an objective. That is a whole nother level and pretty reprehensible. But unfortunately, it's a reality in the system right now that's, I think, in the years that I've been practicing, has only just increased.
Is it because they feel like they don't have another avenue?
I almost think it's because, I have people, everyone thinks that because they went through something, they now need to be compensated in some way. So they almost feel like, I went through this marriage and I had certain expectations. My expectations weren't met. I had this relationship and I had certain expectations of this relationship, and my expectations weren't met. So now I want my pound of flesh. I want to get something for it. And in a way, they feel justified in trying to come after the other person, as opposed to like, you know what? It takes two to make a relationship work. And yes, maybe someone's more at fault in one thing and the other one's more at fault in the other thing. Yes. And actually, maybe there's mental illness and only one person is at fault. And it's not even like it's only their fault as to what they can control based on their mental illness. But the bottom line is, that's still just, you don't get compensated because it didn't work out. There's no compensation. And I know this because people say to me, but so-and-so cheated, so what am I going to get paid for it? So-and-so was not nice and wouldn't come home all hours of the night and overspent on this and overspent on that. What do I get for it? And I just say, like, divorced? You get divorced. You just move on. And I'm not a therapist. So when I tell them this, I want to say to them, like, speak to a therapist, because you do understand that, like, money is great, but your peace of mind and your ability to live every day and breathe and function and be productive in your life, that's more valuable than whatever money you think you're going to get here or whatever revenge you're going to exact on the other person.
There's one way you said it that I guess I take a little issue with. Not that you're wrong per se, but I just want to clarify. When people do allege something, even if the person's gonna settle, are they really ever gonna get past that? It's gonna be money's money. Maybe you'll end up with a few extra dollars, maybe. But you're going to be stuck in a place where you had this allegation, you have this mistrust. How do you move past such an allegation?
I don't think they do well. And I think it hurts families permanently, because you can't trust somebody. First, you can't trust somebody who's made an allegation that you believe is false. If they've made an allegation against you and it's false, you know that person is willing to go to very great lengths and doesn't have just the proper boundaries in behavior and interacting with you. And you're always on your guard as to what, when's the next shoe falling? I don't know if you've made allegations against me in the past that were false. What are you going to do in the future? And I have people telling me, I will never do an exchange for pickup and drop up without a body camera. I will never do it without a device recording. It's a sad way to live.
Imagine what the child feels like with that.
Absolutely.
Yeah. So I do think, just to clarify, obviously, someone that's going to make a false allegation, whether you're going to do better in a dollar or a cent, you're going to really ruin your chances on moving past. One of the sad truth of the allegations, there's this, I guess you could call it a joke, but this guy tells the other guy, if you're not going to do this, I'm going to tell everyone that you did whatever and whatever to my sister. And he's like, but you don't have a sister. He's like, okay, you could tell everyone that I don't have a sister, but once it goes out, it's very hard with all the proof. And sometimes the more it's discussed, the more it's even, oh, well, maybe he did have a sister. Maybe he didn't mean his sister. He meant someone else, but he called it his sister. It always gets to like some other place.
The whisper of any type of allegation it can grow, and it's not something once made can be easily taken back. It just can't. It's a big problem. People's words, and they matter. It depends on the person, and they're also their conscience. Like, I have people who, it's funny because I have people who come to me and they don't approach me with what's going on in abusive. They're just like, how do I make sure I'm stable and the kids are stable, and what can I do? And I'll talk about like, okay, so, why don't we arrange a schedule? Oh, but I have certain fears about this and that. Well, why do you have these fears? And then they start telling me things about the daily lives that they lead with their spouse. And I'm horrified because sometimes I hear things that I can't believe. That to me is overt, obvious. It's abuse. You can't, like, just crazy things that I hear. Those are the people that aren't coming to me to make allegations of abuse. They live their lives thinking that that's what they deserve and that's how they're living day to day. And I have to be the one to break the news to them. This is not acceptable. Your children should not be living like this, and you should not be living like this. And they're the ones that are reluctant. They will not want to report anything, make any allegation of abuse. They're terrified of it. They won't do it.
For sure. That's something that I think I see as well. Like, where let's just again back up a second. As much as what we're discussing right now about how a lot of times there is things that are not necessarily abuse for sure exists, and we do see it a lot. But like you're saying, is that a lot of times the abuse, they're not the ones that are going to be speaking up. They're not the ones that are going to be making any claim or anything like that. And I do think that part of moving us to a place where we could have more peaceful divorces in the world, people for sure should be aware, once it's going to come to a safety issue, it's going to be much harder. You're not going to be able to sit down if there's order of protection. You're not going to be able to work things out together. There's going to be higher things at stake. People aren't going to feel safe. So if you want to have a good divorce, stay away from anything that looks or smells like abuse. If you're getting divorced, there's no point even to have a verbal outlash. Like, what are you gaining by doing that? How is that helping you out at all?
I definitely agree with that. I think that's in the cases where, the fighting has gone too far, where it's abuse, where it's pervasive, and the person who's the perpetrator there has to be some degree of just lack of control and mental illness there, where that person can't think that way. Those are the cases where that's abuse that on its face, I don't think anybody can counter. The real issue, or say there's any false allegation, the real issue is when it's like you're fighting too much and you're fighting about stuff and you're just creating this pressure cooker. So somebody's going to do something that's going to make them look bad. Those are the cases where if you're thinking of divorcing, de-escalate. As a matter of fact, saying, let's not have these conversations. And if we're going to have the conversations, let's do them with a therapist. Let's do them with a mediator. Let's just table it. And definitely let's not do it in front of our children. Because when that happens and then one person loses their cool that day just because things have been so bad, all of that can be chalked up to, you're the bad guy, you're the bad girl, you're out of here, and excluded. And it just spirals that situation out of control.
Right. I want to move over to like custody. But before we get into there, I would just share like what I tell clients always is like, I want them to always have a sacred communication between the two of them. Where there's certain communication that you could always have. You're going to need to communicate one to another. Nobody could get that text through to the other person that you're going to be a half hour late. It's not possible. So you're going to go through some parent coordinator to go get that message through. It's not going to work. So there's some level that has to be sacred. And I tell them even, have a safety word. Not a safety word, but have a safety word. Have a safety word that is, okay, this is a conversation that we cannot have anymore. and we'll deal with it someplace else, and we'll deal with it not in the moment,
Right.
and we'll get through the moment. But moving over to custody, there is this word that a lot of people like to say: custody in the court's going to be 50-50. Is that true?
So if you're asking me in New Jersey, I would say it's more true in New Jersey. There is a presumption of 50-50. But in New York, not really. It's just about what the children's best interests are. And presumably, the most time that a child can have with both parents is the best for that child. But there are other factors: schedules, distances from certain places, homes to schools, the children's routine, the children themselves. Some kids don't like going back and forth. They just don't like it. It's not for them. There's other things that work better for them. So it's an approach of, what do these children need? What can we do for them directly? And also, I do stress this. It's about quality of the time, not the quantity. It really is. And so some people think it's even Steven. It's not about that. It doesn't matter. It's about what time you actually spend, because the truth is, if you're doing the day-to-day, pick up from daycare, run home, bathe, feed, homework, in bed, bedtime, pajama, that's okay, that's time. And there's moments of quality to that. But the truth of the matter is, that's not the time where you're building those big, beautiful memories with your kids. That's the time, that's the grind that everyone just goes through and forgets. And I have some people say to me, frankly, let the other parent do that. I'll be Disneyland mommy or daddy. I can just have fun on the weekends. But yes, both parents should have a part of that, but not every parent. That's not always their department or what they're good at.
Is the presumptive for, let's say, weekends, holidays, vacation time, whatever you qualify as the family time, is there a presumption that is going to be 50-50?
I think so. I think in every state that I practice, both New York and New Jersey, those times would be 50-50.
And then it's really the Monday to Thursday that's the big question of what happens Monday to Thursday.
Yes.
So that's a different, right. Now, let me just move back to the court, because as much as people say in court it will be 50-50, to some extent, that is, I'm sure you've heard that also.
Absolutely.
There's another idea, whereas if you're going to end up in court, where you're going to end up in trial, there's going to, and as much as in mediation, it's almost always shared custody, because shared legal custody, because if you're able to work it out in mediation, maybe someone needs a final decision for something, but you have some way of working together. But if you're going to end up in a trial in court, is that where it's really more common, where the judge says, well, you guys can't work together. If you need me, then either custody's ending up on me or I give it to one of you.
Well, it's not custody's ending with the judge. That's never an option.
The judge, but
right.
You're always going to end up back by the judge if the
right.
two of you are going to be the
judge is going to have to choose one. And here's the crazy part. It's not that the judge thinks, one parent's better than the other. The judge might think both parents are fully capable, but the judge actually will only have no choice but to choose one. And litigants need to think, do I even want to go there? Do I really want a stranger to now decide, a very nice stranger who's going to listen to everything and do their best, but make the decision about who's making decisions for my children for the rest of their minority? Or can I just buckle down, get my head in this, and do my best to do things right? Just work with my other parents.
So it's really like, if you're going to end up in court, you're probably not going to end up with a shared 50-50, more than in court you will end up with a shared 50-50, because it's kind of not going to be possible. So that's kind of like the contradiction in court says 50-50. Where does it say it?
Well, there's a variation on that, because, sometimes people can't agree to what the language is. So they'll end up going to court and they think that they both, individually, each want legal custody. And we're talking about legal, not the physical part now of this. But they don't, but the history of what their interactions are is that they actually do work well together, or well enough. There's nothing missing for the children in decision making. They seem to have gotten along for many things. And so the judges are kind of confused. Like, you just want it because you want it, but you don't actually need it because you work well together. And so in those cases, judges can say, well, guys, joint legal, and maybe like there's a PC to like work out any differences you have. But they see that
PC's parent coordinator.
A parent coordinator to help work things out. But a judge will see all the emails, all the text messages, all the communication. They'll know what the status of what's going on with the children. And they'll say, well, when so-and-so was sick, dad called mom and said sick. Should we make a doctor's appointment? Mom said yes. They coordinated the appointment. They both showed up. One picked up the prescription. The other brought it to the other house. They transferred the prescription between homes. They checked on each other in the night. Hey, does so-and-so still have a fever? They worked well together. They made sure the child was sick. The child was taken care of. Both parents were involved. The child had a school issue. Both parents show up. They attend PTA together, parent-teacher conferences together. That's a history of me growing up in Brooklyn as a kid. That's what we used to call it. They work together in so many different fronts, but for some reason, they just wouldn't agree. I've had cases like this. They just wouldn't agree to sign for one person to share custody with the other, or they both wouldn't agree. And judges have said, well, I am ruling that you'll both have joint legal custody.
What's really interesting to me is when parents over religious issues, they're like, no, we're going to take this all the way to court because of this religious issue. And it's like, you're going to go in front of a judge who's not even your religion over a difference between two parents' religious issue that they might not even per se understand.
So those are really hard cases, really, really hard cases, because especially with the more religious observance that there is, that also encompasses education. It doesn't just encompass religious practice and whether or not there's going to be a bar mitzvah or a baptism. It's about an entire way of life and an education. And those cases are case by case. You can't paint them with one brush. It really is about that child, that family, and the individual needs of that family and what it is that their specific, factors are. It doesn't, I couldn't even begin to touch on one answer. And I have so many things, like I've done this. So it's a tough one. That's a very
I think it's much
tough
harder
one.
as a lawyer than as a mediator. As a mediator, religious differences I happen to really like, because what we want in mediation is that both parties understand that we don't see things the same, but we need to figure out how to coexist. And when there is religious differences, they understand we really don't see things the same way. And they understand that in religion, if I may say, it's a belief, right? So it's the greatest minds have argued religion, and that's not where it's going to end. You're not going to battle out whether religion is or isn't in court.
A question forever.
Right. So it's something that you're going to work out together. And how do we work through this? And when people work together, understanding that we see things are different, they're miles ahead of other people where maybe the same in a lot of issues, but because they're so the same, they don't necessarily understand this idea that there's such a thing of us disagreeing, and which makes it a lot more difficult. And I would say also in the legal arena where you're representing one of them, it's more difficult because you don't have that conversation with both of them per se.
But I try to, and I think I'm successful with my clients in trying to inject reality and to say, look, this is your belief, and you need to think of a way to make this palatable for both of you and to see how we can settle, and also to really think about your child, because if your child's growing up in two households that have disparate belief systems, you still have to make sure your child's comfortable wherever they're going to be. And so I first and foremost like to be practical, because it is a family that we're talking about, and that approach can never hurt. Just what can we do from a practical perspective? And so I try to inject that, but it's not so simple when, there's one side saying religion or some degree of religion and another side saying no religion at all. And I think in that case, the reason why they're at litigation, they're litigating is because they just can't come to a place where they can want to see the other person's side or come closer to meet in the middle. And sometimes, I find I'm bringing my client to the middle, but no one's coming to meet us in the middle. And so,
Right.
and other times I represent clients who are very reasonable in every other way. And in some way, they're fixed on some idea, and that's it. And look, my job as their lawyer, it doesn't matter what I want. It's what they want. And so I need to advocate for that.
Mediation, we have like techniques for these situations. I'll share with you one technique. I guess I'm wondering your thoughts on this. When you have this is specifically for someone that's not religious. Someone's not religious, someone is religious. One of the questions that we want to ask the not religious person is, what is it that you don't like about the religion? And a lot of times the religious person would agree with what the person that's not religious doesn't like about the religion. I'll share with you a story that I had where it actually played out beautifully. The wife was the not religious one, and part of her experience was that she was abused from a religious leader, and she expressed that to the husband, and the husband's response first was, well, if he did that, then he wasn't religious. That didn't go over too well. And further on, where the husband was able to say that absolutely abusing someone is wrong, abusing someone is bad, and I'm with you on that is not something that's in my belief. That doesn't, or you could use the same thing in education or stuff
Right.
like that, where what the person doesn't like is something that you might not like either as a religious person. And the more you're able to be open to what it is that they don't like, you might not believe in the same religion that they don't believe in.
Right.
And I've seen that play out very, very nicely a lot of times, where they were able to figure out something else that they could do that aligned with somewhat of both of their beliefs. And that's not necessarily something that you could do where it's a combative situation.
Right.
But when you're working together, you have so much more leeway in finding that understanding
Common
between
ground.
the two.
Yeah.
Or even, having the discussion like, one parent keeps Shabbos, one parent doesn't keep Shabbos. How would you like for me to address this topic? And you speak to each one of them. If the parent that keeps Shabbos is going to be telling the children when they go to the other parent, well, maybe try not to use the electronics, it's going to be a much harder co-parenting.
Right.
And if you could have that conversation of what you expect, you could see so much more happening in those situations than where you're taking the opposite approach of each person trying to pull the child and
Into their direction.
right.
Yeah.
It's really living by showing, like, I'm saying this
Leading
wrong.
by example.
Leading by example much more is how things would actually be able to be productive. Let's skip over to what makes your best client.
I have a lot of very good clients, but I would say is that the ones that are open to discussion and want to, like, they may have a point of view. We can discuss it. We can try to really work something out and be solution oriented, not just stuck in a position. And I think that's sometimes where there could be a breakdown where you can't communicate with somebody. It's a similar thing, is that there's nowhere to go, because even with litigation, you have to take a position that you can prevail. If you're going to take a position that's unreasonable, I really can't be that helpful as a lawyer. And so while clients may have some ideas of what they think they want or they should be entitled to, just their being open to listening and us having a discourse. And I have to be open to listening to what they're saying. And I that's one thing that it's important to me to do. Not from a therapy perspective, because I do have to sometimes tell people, like, I'm not a therapist and this is way too pricey, an hourly rate for me to be listening to. And I also, I can't help you in therapy. So I sort of have to back off that, but discourse for how we're moving forward, what types of plans of action we can take to achieve what needs to be achieved for, the best possible outcome for that litigant.
And what makes the worst client? Just going to, what are you
Yeah.
repulsed by when a client tells you?
So, I mean, I think worst for me is just unreasonableness and an unwillingness to listen and to allow to hear what's being told to them, and just a certain type of unreasonableness. Because no matter what, I have my own, desires for what I would see as a great outcome, but it's not about what I think is a good outcome. But if there can't be discourse and I can't have like a reasonable discussion about what a possible outcome is, and you say to me, no, I want 100% of everything, and I want them to have nothing. And don't think I haven't had these. I've had clients like that, and I have to keep saying, that's not how this works. It just doesn't work that way. This is what the law is. This is what the outcomes could be, but there's no other option. And sometimes I'll have that conversation like 3 or 4 times, and I'll have to wonder to myself, like, is this a viable relationship? Can I continue? Most of the times I find a way to work through it. And a lot of times that's by me just being very persistent in educating this client with repetitively, which is sort of a waste for them that I have to keep repeating, but necessary. And then once it's accepted, we can move forward. It's just so much harder because in not accepting the bare truth of what needs to happen here and what the parameters in which it can happen, it's not helpful to a client. Like, I'm not here just to deliver bad news. I'm here to tell you the truth as I see it and counsel you, not because I don't want to give you what you want or get you what you want, but if you can't get it and it's not possible, I need them to understand it. So those, I think, are the hardest ones. And then also the Google educated clients can be somewhat difficult at times, just because they'll come back to me and say things like, well, I Googled it and I should be able to, I don't know what. I've had so many things. And then they'll say to me things like, my friend told me in their divorce, they got. My cousin said, and I'm just like, listen, I'm going to tell you, I don't know your cousin's situation, but I'm telling you, divorce is a case-by-case basis. I don't know what happened to your cousin. I'm happy for their lives, but that's their confidential life, their privileged information. I don't want any part of it, but this is what I can tell you based on your case and my understanding of your case. And my other thing is I say, well, every time I Google my headache and I want to find out what I have, it's usually cancer. So good luck with that. Google's just not giving you the right answer.
So one thing that I totally stopped accepting from clients is when they try to tell me how to do my job. So whenever they're like, well, why don't you do the mediation this way? Or why can't that work? And I'm like, look, you wouldn't hire me to hang up your chandelier. You're hiring me for mediation because I'm good at what I do. And I'm very good at what I do. But I'm very good at what I do because I do it my way, because I know what works and what doesn't work. For me to start doing it your way, either find someone that could do it for cheaper or, because that's not my expertise. So you have to fit within this system. Obviously, I'm not going to tell you what you should want or how you should want or what you should do, but you can't expect me to do something different than what I do. I'm a mediator. I practice a certain way. And if you're going to want me to tell someone off or for me to do something specifically in your way, how you think it should work, I'm not going to do that. I'm not going to be a part of that because that's not what I do. Now, moving on to
I think most people appreciate that, and they should, because that's similar to how I operate. And I think that the confidence and the understanding that they know you're doing your job the way you know how to do it successfully makes them feel like, okay, I just need to buckle down and stop, trying to micromanage everybody else around me. Some of that may play into why relationships aren't working out right now. So it's
right. I don't think the person I told today liked it, but I really hope that they don't come back, because I don't think that they're ready for. It was actually a consult, but I don't think that they want my service. But let's move on to what is known. What is known about child support, the calculations, alimony, maintenance, right? These calculations, now they're calculations, and sometimes it doesn't add up. Sometimes it's just not fair, especially if someone's paying private school tuition.
Right.
there are times where the calculation does not work. I'll give an example. You have a couple that they have 50-50 custody. One is making 90,000, the other one's making 100,000. The $100,000 spouse would have to pay the $90,000 spouse for one child $17,000. Now all of a sudden the $90,000 spouse is making 107, and the other one is making now only 180, whatever the math is, 183.
Right.
Yeah. So it doesn't always add up and work out perfectly. Or another example would be if you have 40% custody, you're paying the same much as if you had 2% custody. So how do you guide people through this?
So let's go to the first example that you gave. I think in that example, 90 to 100, that wouldn't make the difference. And I've been in front of judges who said, I'm sorry, those are basically similar incomes. We're not talking about much. So
in 50-50.
In 50-50.
Right.
And judges would not, especially when joint income there is barely, above the cap. It's hard to live on that kind of money. And judges know that, let alone if they're paying any sort of tuition with that income. That's really just month by month of, money out the door and probably living at a deficit. And so the practical nature of that is if I would write up any motion to explain, hey, this is the calculation, they just don't have it, it's not here, that would be taken into account. I think it works out most of the times in those scenarios. It does. And also, the person making 90 knows that that their spouse only makes 100, or the parent of the other parent makes only 100. It's not that far off. They know there's no place to get a windfall. So those cases, while they're difficult cases and they're very hard cases to settle sometimes, I think there's not much risk going to court and showing or even at mediation, seeing the numbers practically and thinking oh, I'm entitled to, he's the moneyed spouse or she's the moneyed parent. That's not going to happen. Everyone knows that's not really the disparity of who's moneyed and who's going to be the custodial parent for child support purposes. But in your second scenario, which was the 40% of parenting time to one parent and the, having to pay the same amount of child support. So those cases are a bit harder because they just are. And it depends on if that 40%, what's the disparity in their income, 90, 100 or 200, 150, or, what is it? And are they paying tuition and what percentage of tuition? But I have done cases where it's close and tuition's high and there's expenses and they want to send to those private schools and they're not getting the breaks that they need to be able to send. And there's going to be some give and take there. There's going to have to be a negotiation where reasonableness needs to prevail to some degree of there isn't this money here. It just doesn't exist in this,
right.
In this way.
I think harder really is the situations where you have one spouse not working and the other spouse is earning $100,000.
It's terrible.
And then you have alimony, you have the maintenance, you have the child support, and you have private school tuition. And then you look at the numbers at the end and you're like, wait, what's left over? So
at that point, there's going to have to be something that gives. And while private school, and I understand if there's a parochial education, we're talking about religious education that people don't consider to be extra, they consider to be a necessity. There's certain communities you're going to be talking to. They're not going to say, oh, my other option is free public school. It's not an option.
Let's just clarify that, meaning you do hear a lot of times where someone says, well, then I'll send to public school. If they sent to private school every single year for the entirety of their marriage, would a judge just say, oh, yeah, sure, you could send to public school? Or is that less common?
If the child has always gone to private school, it is harder for a judge to say that. But if there really is no way to pay for it and there's no funding for it from anywhere, not a charitable organization, not a scholarship, there's nowhere to pay for it. And so maybe there's an obligation that someone has to pay, or they both have to come up with some money. But in the end, ultimately, it's not money that they owe the other spouse. It's money that they owe the school or institution, and they'll have to deal with it. But if somebody's earning $100,000, has to pay child support, spousal support, and 100% of all expenses, there's no money left to buy like a sandwich. It's not possible. And so there is reason here. The law on its face, black and white, is very difficult for that person. But if it goes to court, if it does go to a support magistrate or a judge in a divorce, there will be calculation. There will be an eye into that.
And it would be just as much of a difficult situation for the non-moneyed spouse.
Right, because how much are they getting already? Even with the calculation on $100,000 with one, that's still not enough to make the rent and pay the grocery bills. There's still going to be somebody that's getting food stamps, Medicaid. Like there's going to be, it's a problem.
So we did not figure out the solution.
We don't have one.
Right. We did not figure out the solution for people to how they're going to live. Now, let me just ask you as we wrap this up. I'm going to wrap this all together. What improvements would you want to see in the court system, in the Beis Din system, in mediation? What improvements would you like to see?
So, I mean, changes in the court system, just because now I think the courts are so backed up. I don't know how they would speed things up, but there has to be certain things addressed, I think, in a more timely manner. I don't have a solution for how they're going to do that. It would be lovely for that to happen, but I don't know that they have the resources. I think that I've been in courtrooms where judges are just, the amount of cases that they have to hear in a day, the dockets are just so backed up. They need help. As far as Beis Din, I've had some really productive experiences with Beis Din. Things arbitrate much more quickly than courts can address things. So there's that very important factor, that like the finality and time being important, but then you still need to confirm orders of a Beis Din in the court. So you run up on time, but at least you have a solution.
Which I think is one of the difficulties that people don't realize about Beis Din, is that after you get the Beis Din or the arbitration to issue a ruling, how do you turn that into a divorce? Which I think is a costly process, unless both parties are agreeing to file uncontested.
Well, yes. And because if there's not going to be a confirmation, there still has to be a motion to confirm. Hopefully it's unopposed. If it's opposed, that's a process. Once it's confirmed, then you still have more paperwork to do. And it is a process, but at least with a final ruling, you have some basis on how to move forward. It gives something. And I think that some of the arbitration panels are good. When they find items that the parties agree on, they have them stipulate to those items, and they'll only rule on certain. And maybe that's an improvement that they need to be thinking about, is put less into a ruling that needs to be confirmed and try to see what the parties agree on and get that signed off as a stipulation. So there's less work in confirming what a final ruling is. Which
is one of the things that I really wanted to see much more. And whenever I speak to arbitrators or Beis Din, I always tell them, like, I hope that the clients going in know what to expect. And they know what you're offering them. And even when you have a mediation within an arbitration system, a med arb or a Beis Din trying to do mediation, I hope that they're clear how that works. Because a lot of times that's not going to be based on the needs of the party. It's much more claim-based than need-based.
Right.
So that's something that I think they have to clarify to draw out more what it is that you should expect going in.
And what options there are that you could have this like mix of mediation and arbitration. It depends on which, organization's doing it and how they approach things. And then with cases that I have, I don't always have the option of where it's going to arbitration. I get it where it's in arbitration, or where there's no option. This is where it's going. And so we work with...
Would you let anyone go to arbitration would you ever recommend for anyone going to arbitration without an attorney?
I don't recommend people to do most things without their attorney if they're making these big decisions. So I actually do with mediation. The reason why I do is if both parties are unrepresented in the actual mediation room, but they consult with an attorney on the outside to talk about what their rights, their options are. So they're educated in entering that mediation. I 100% do say both parties come to the table have your neutral mediator talk. Go out. You can talk to your attorney about the ideas, the discussions, the points that were reached. Absolutely. So that you're making an informed decision, and step by step at the process of mediation, you feel that you have a comfort level. Because if you don't, and you're not building up on what that final, agreement's looking like, it could all fall apart at the end.
Right. So I think in a lot of cases, and I'm probably more of the cases that you represent, I do believe that having an attorney to speak to or bringing your attorney is a good thing. But I think that there's a lot of clients that they're looking at really a very basic divorce where I feel as long as you're 100% comfortable with what it is that you're agreeing to and you don't have an attorney, I'm much more comfortable. And I totally understand why someone doesn't necessarily need an attorney if you don't feel that there's something that you're not happy with.
It's funny that you say that, because somebody called me for a consult. I spoke to him. He wants to go to mediation, and he asked me with his scenario if he needs a mediator. And I said, I don't, an attorney at mediation. I said, I don't think that you do. You can always consult with somebody on the side, but I really don't think, with the basic understanding of what it is that your scenario encompasses, that you need that. And so then he asked me if I had a recommendation for a mediator. And I said, yeah, I do. You can call Concord. Because it worked out. So there are people who do call me. They give me their, and I'm not going to waste somebody's time and say I can represent. There are people that call me with all sorts of, I can't actually help them, or I don't think my expertise suits their needs. I will very clearly and without hesitation tell them and direct them if I can.
I think one of the things that you're very fortunate with is that you're not tested, because you do have a lot of people reaching out to you. So I don't think you're tested in that regard to take a client that's not a perfect fit, which I think, again, is a great situation, which unfortunately not everyone is afforded, right? Again, not to diminish. I do think that it's great your ethical your ethical approach. Let me move over to a different area about mediation, because anyone could call themselves a mediator, right? And you do have the person down the block, or, where are you wary? What should people be wary of a mediator when something happens, or someone calling themselves a mediator? What should people be careful with?
Well, I mean, they need to look for someone who actually has the credentials, the experience, because mediation isn't just somebody who decided to say, oh, I'll be in the middle and I'll work this out. No, there's actual expertise. There's a method. It's work. I've been to many mediators with clients, and I see the difference in the approaches. And I can say that there are mediators that are really good at their craft, and it is a craft. And so not anyone could just say they're a mediator, just sitting in the room and, saying, oh, okay, you agree to this and you'll agree to that. That's really not what it's about. People do need to vet and make an informed decision about who they're going to. I think that, some cases, depending on who the parties are, benefit well from mediators who are attorneys, some from mediators who are non-attorneys, some mediators who have a background in social work, and then also former retired judges. Depending on the types of cases, they have more success based on also what the background of that mediator is.
Do you think custody cases are ever about the children? Now, I wouldn't say ever. Let's say most of the time. Do you think they're really about the children?
A lot of times, yes. And then there are times that there aren't. They're not. It's about control. So, I mean, and then also I can say that certain parts of custody cases are just about the children, and the other parts are like, that's just because you want it your way. And let me explain to you, I'm a person who likes it my way too. Right? And I like to be in control. So I get it. But the separation and understanding of, this is not about just what the kids need. This is about what you want. You have to sort of like evaluate that, think about that some more. And sometimes, look, if I'm representing someone and that's what they're thinking, I can say like, hey, why don't you think about it this way? Or what about if a judge would look at it, or somebody objective? They might think that this is what this is. What do you think? And sometimes they'll say, I did think about what you said, Miriam, and maybe I can just, back down from that. And other times they really don't see the forest for the trees. They think that that's really about what the kids need. I'll get things like, exchanging clothing, like who gets the clothing and who buys the clothing and who brings the clothing back, and the sports gear, and it's all about the kids. And I'm like, it's really not. Like, Walmart's really not that pricey. You can get a few more things. You can figure it out. There's so many options for that. It's just about some stuff. You guys are putting a lot of emphasis, or one person is putting a lot of emphasis on something that should not matter. And that's usually not about the kids. It's about the control.
I think that a lot of times what judges are looking for, and I think that it's a good approach to think, they're looking for it to work out. That's what they want. If you're going to be the one making issues, making it not work, and the court is looking for the best interest and the health and the well-being of the child. On the court website, you have a parenting course, a parenting book. There's sometimes where parenting courses are mandated for the parents, and even just the Bill of Rights of Children are on the court website. And I think sometimes, like, before you say exactly what the law is, maybe just read that book, which they say that's what they guide you by. They have this Bill of Rights, which they want to see. So they don't want to see you communicating through this child. That's not what they want to see. So if you're someone that's there to make it work, to make this new relationship work, you'll do that much better in court. But in general, just if you're looking to resolve it, you're looking to resolve it. If you're not looking to resolve it, and whenever you approach it that way, obviously any peaceful resolution, you can't force a peaceful resolution. For sure, not a mutual peaceful resolution. You can't force it. But you could be there ready to accept and be ready and available to have that. And try not to do things that would really derail you from being able to do that. And I'm thankful really that, first of all, that you came on, but also that we have lawyers like you that are able to stay even keel and really try to calm down a situation. But at the same time, you're there to protect people. And I know you've protected people and stood up. And it's not a settlement from a place of weakness. It's a settlement from a place of strength, of feeling empowered and knowing what is out there, not being scared to walk into the courtroom. It's rather knowing that I could come to a settlement where we could move on, we could do this jointly, we could work together in the future, and maybe even make a party together for our children sometime.
Right. I will say this, that judges in all family and matrimonial, they really want the parties to come together and settle. They do want that. They can't force it, just like you said, but that is ultimately what they're looking to see if that can happen. And they're looking at who's making a reasonable effort at trying to do that. And the majority of my cases don't go to trial. As much as, if you look at my schedule, I do go to trial often enough. But if you look at how many cases I settle, it's just a mere fraction of what ends up going to trial. But there are unfortunate cases where you just can't get a settlement. I think that for the most part, judges are looking for settlement, and parties want settlement. They want to, and they should want it. That's what they should be thinking of. Just, there's the path to how to get there.
Thank you so much. And obviously, everybody out there, subscribe to continue your journey in learning and desiring peace. And if you want to reach out to Miriam, how should they reach you?
Our website is truelaw.com, spelled TREU law.com, or our firm is Treuhaft and Zakarin. And
anyone that puts you into Google, they'll find you pretty easily.
Pretty much.
Yes.
Yeah.
You reach the top.
Yes.
Thank you.
Thank you.